אנחנו מטילים מצור מוחלט על העיר עזה. אין חשמל, אין מזון, אין מים, אין דלק. הכל סגור. אנחנו נלחמים בחיות אדם ואנחנו נוהגים בהתאם.
This statement by Israel's Defense Minister, Yoav Gallant, forms part of the 84-page document submitted by South Africa to the UN's International Court of Justice, in which they accuse Israel of violating the 1948 Genocide Convention by committing acts of genocide against the Palestinian people. It argues that the invasion of Gaza intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnical group, claims that Israel denies. But what exactly is genocide in the eyes of international law, and how do you prove it?
Dr. Lemkin, could you give us a little background on how you came to be interested in this genocide fight originally?
I became interested in genocide because it happened so many times. It happened to the Armenians.
This is Raphael Lemkin, a Polish Jewish lawyer, who, after losing much of his family in the Holocaust and researching the ethnic cleansing of the Armenians, wanted to come up with a term befitting crimes of such magnitude and help liberate mankind from this odious scourge. Lemkin lobbied the newly formed United Nations until eventually in 1948, the Convention on the Prevention and Punishment of the Crime of Genocide was approved, becoming the first human rights treaty, contracting parties to confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and to punish.
Now we are protecting the most fundamental right of all, the very right of human groups to exist as groups.
In the years since, the world has witnessed many examples that might fall under the UN definition of genocide, but only a handful have led to trials in an international court. The International Court of Justice, a civil tribunal that hears disputes between countries, has only heard 4 cases involving the Genocide Convention in its history, and only one of these has been legally recognized as genocide. The international criminal courts, criminal tribunals that prosecute individuals, have tried and legally recognized 3 instances of genocide, and even those have been very difficult to prove, with a limited number of convictions.
Non coupable du crime de génocide.
According to the Genocide Convention, criminal acts which would constitute genocide include killing members of the group, causing them serious bodily or mental harm, creating conditions calculated to destroy them, preventing births, or forcibly transferring children to other groups. But these acts must be proven that they were committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. It is this required intent that sets genocide apart from war crimes and crimes against humanity, and consequently makes it very difficult to prove. This burden has been challenging for international courts to fulfill, and has led to defendants being acquitted due to legal formalities, or foregoing genocide indictments altogether in favour of war crimes and crimes against humanity. And there are also those who have been indicted for genocide, but who have never been brought to trial due to a lack of political cooperation. It's these difficulties that have led to criticisms of the international courts.
We cannot raise expectations so high and achieve so little so often in the courtroom.
Le Rwanda appartient à ceux qui le défendent vraiment. Et vous, les Burundi, vous n'êtes pas des Rwandais.
The International Criminal Tribunal for Rwanda was the first international court to hand down a genocide conviction in 1998, sentencing Jean Kambanda, Prime Minister at the start of the genocide, to life in prison. The first time a head of government had been convicted for such crimes.
Jean Kambanda knew, or should have known, that massacres against the Tutsi civilian population were being committed.
The tribunal indicted 93 people, convicted and sentenced to 62, and acquitted 14. However, this represents only a limited number compared to the thousands involved. As the ICTR wound down its work, the remaining defendants had their cases transferred to national jurisdictions, while other suspects died before being presented before a judge. 2 fugitives remain at large. The case against Pol Pot's Khmer Rouge regime, which caused the death of an estimated 1.7 million Cambodians, fared far worse in its attempt to deliver justice to victims. The trial followed years of obstruction by the then Prime Minister, Hun Sen, a former Khmer Rouge commander. It took 28 years before anyone was formally charged, and the proceedings lasted another 15 years at a cost of $330 million, and only led to 3 convictions. There are still established figures in Cambodian politics today who previously held positions of influence within the Khmer Rouge. One clear example of genocidal intent was in the case of Serbian general Ratko Mladic, who was charged with genocide for ordering the massacre of over 8,000 in the town of Srebrenica, and for a wider campaign of ethnic cleansing in municipalities across Bosnia.
I napokon došao je trenutak da se posle bune protiv Dahija Turcima osvetimo na ovom prostoru.
But he was only found guilty of genocide in the first count, where a body of forensic evidence and eyewitness accounts proved that systematic executions occurred in Srebrenica, but was acquitted of the second count on the grounds there was reasonable doubt over intent.
The chamber was not satisfied that the physical perpetrators possessed the required intent to destroy a substantial part of the protected group of Bosnian Muslims.
Madam President and distinguished members of the court, I will address Israel's genocidal intent.
Israel denies that it's committing genocide and says its military campaign is self-defense.
How could anyone possibly argue that Israel could not defend itself faced with the 7th of October atrocities and the incessant attacks against its civilians since?
However, in its application to the ICJ, South Africa has presented quotes from top Israeli officials as evidence of inflammatory language, pointed out the high number of civilians killed, and also the destruction of schools, hospitals, sources of food, and places of worship. The court has already ruled that Israel must abide by a series of provisional measures, such as ensuring its military abides by the Genocide Convention, and to allow unimpeded access of food aid and humanitarian assistance into Gaza, where sections of the population are facing starvation.
This is the highest number of people facing catastrophic hunger ever recorded anywhere, anytime.
The judges have also called for the immediate release of all hostages being held by Hamas. How the court decides to proceed with this case will set new precedents for how we define genocide in the eyes of international law for decades to come.
Some might say that the very reputation of international law, its ability and willingness to bind and to protect all peoples equally, hangs in the balance.